In the last two chapters, we focused on the area of tort law, and specifically the tort of negligence. In this lesson, which is 3 parts, I'm going to introduce you to the most important remaining torts that arise in a business context. So here's what you need to know. You should know the range of torts that are relevant to business organizations, how torts arise from the use of property, how they arise from business operations, and how they can manage the risk of liability in tort. The terms that I would like you to be familiar with are on pages 289 and 290. We've got 3 cases in this chapter, and they are TMS Lighting versus KJS Transport, R versus Chen, and then Ciba Geigy Canada Limited versus Apotex. So tort law comes into play in different ways when it comes to business. Tort can be committed by a business through their business activity, but they can also be the victims of torts. So some of the torts that are committed by organizations could be customer slip and falls, a loss prevention worker detaining a shopper who is innocent, or even if a salesperson overstates the quality of a product. Some of the ways that organizations can be victims of torts would be if a report of some kind maligns some aspect of the organization. It could happen if vandals damage property or if a competitor steals an employee. Torts that are relevant to business can be broken down into 2 categories that we're going to look at today. Those are torts that arise because a business occupies a property, or torts that arise because of actual business operations. So this is figure 12.1, and it lays out the torts that we'll be discussing in the lesson nicely. We're going to start at the very top. We see torts and property. So as I've said, we're going to start with torts that arise because a business occupies a premise. And we're also going to look at some basic terminology. So first of all, what is an occupier? An occupier is any person with a legal right to occupy premises or has some degree of control over land or buildings on that land. So the owner of a property, very obviously, would be an occupier. A tenant is also considered an occupier. They have a legal right to occupy the premise and they have some degree of control over the property. A temporary provider of a service could also be considered an occupier. So take an elevator repair person, for example. They have permission to be on the premises, and while they're working on the elevator, they have some control over how that space is used. A cleaner would also be considered an occupier. So there are 3 main types of tort action in relation to occupation of a property, and these are occupier's liability, nuisance, and trespass. And we'll be covering all of those in this lesson 3A. So there's an area of tort called occupier's liability. Occupier's liability describes the liability that occupiers have to anyone who enters onto their land or their property. Liability in the common law was determined by classifying the visitor as either a contractual entrant, an invitee, a licensee, or a trespasser. And each of these categories had a different standard of care. Typically, the trespasser was the one that was owed the lowest standard, and the contractual entrant was owed the highest. So we're going to start by defining each of these categories. The first is the contractual entrant. So this is someone who has contracted and paid for the right to enter the premises. Visitors to the premises who've bought tickets to see a pottery exhibit would be a contractual entrant. The duty owed to this class, in the absence of a contract specifying the duty, is akin to the negligence standard. That is the standard of reasonableness. So if somebody pays to be on the premises, the occupier is held to the standard of care that a reasonable person ought to have provided. Next is the invitee. This is someone whose presence on the property is of benefit to the occupier, such as a store customer or delivery personnel. or the aforementioned elevator repair person. The occupier owes a slightly lower duty of care to the invitee than the contractual entrant, but it is still a relatively high duty. A licensee, then, is someone who's been permitted by the occupier to enter for the benefit of the licensee. So a licensee might also include guests invited to someone's property for a social occasion. The general rule is that the occupiers are responsible to licensees for any unusual danger of which they were aware or that they have reason to know about. The latter part of the rule is a recent addition and tends to blur the distinction between the duty owed an invitee and the duty owed a licensee. So that since there's no strong rationale for distinguishing between a licensee and invitee to begin with, this blurring is entirely justifiable. Finally, we have the trespasser. This is someone who goes onto the land without invitation of any sort and whose presence is either unknown to the occupier or, if known, is practically objected to. A burglar clearly fits the definition of a trespasser. An occupier still owes some responsibility to a trespasser. In particular, the occupier will be liable for any act done with the deliberate intention of doing harm to the trespasser, or an act done with reckless disregard for the presence of a trespasser. And we'll talk a little bit more about how much of a duty is owed to a trespasser. Traditional occupiers' liability rules under contract law were often criticized for the difficult distinctions between the different classes of visitors, the blurring of duties owed between the various classes, and the severity of the result when the visitor is classified as a trespasser. Alberta, British Columbia, Manitoba, Nova Scotia, Ontario, and Prince Edward Island have enacted occupiers' liability legislation. This was done to simplify occupiers' liability law according to common law. Legislation in these provinces provides for a high duty of care equivalent to the negligence standard, and this is owed to entrants who are on the property with express or implied permission. So at common law, those would be the categories of contractual entrants, invitees, and licensees. By providing that all three types of entrant are owed the same duty, they have effectively reduced some of the ambiguity around occupiers' liability law. Within occupiers' liability legislation, trespassers are owed a duty of care, but it is a very low duty of care. What the law focuses on here is that the occupier must not create deliberate harm or damage to trespassers. And so digging a ditch for someone to fall into or somehow setting up a trap, obviously that would be creating deliberate harm or damage to trespassers. Now, there's increased responsibility for occupiers if the trespassers are children. So if it is known, for example, that children often cross property on their way to or from school, then there's going to be a higher duty of care owed. Businesses face liability for the tort of negligence, as well as under occupiers' liability legislation, for what is known by lawyers as a slip and fall. I'm going to use an example here that was affirmed by the Ontario Court of Appeal in 2018. So in this case, a patron walked into the Bay store and slipped on some water that had collected on the floor inside the vestibule. The patron was injured, and so they sued. The plaintiff, in this case, was able to successfully argue that the Bay and the property management company were liable under the tort of negligence. The judge awarded $100,000 in damages. They were successful in their argument because they determined that there were no procedures in place to protect patrons who are considered entrants. And so had they had a hazard identification schedule, or if somebody had to check every 30 minutes to make sure that there were no potential slippery situations, then the court might have felt differently. Slip and falls are a really interesting part of law. there's a really helpful resource. It's an article called Using Risk Management to Avoid Slip and Fall Accidents by Yeargain and Budden. I'm going to briefly summarize what the article says. Basically, these authors identified 3 main types of slip and falls that organizations should be aware of. These are slip and fall inside the premises. The second is displays or improperly stacked goods, which could cause injury. And then the third is slip and fall outside of the premises. The part of the article that we're interested in here is the part that looks at risk management strategies that a business could put in place to reduce the chances of a customer slipping and falling. And their first suggestion is that organizations develop an atmosphere of liability cost containment. So working to instill in the employees the necessity of monitoring the firm's property and the necessity of minimizing or eliminating potential hazards. And so when you walk through perhaps a store and you see one of those yellow signs that says slippery surface or wet surface, that's an attempt to warn people so that they're more careful and that they don't slip. The article also suggests that you should assign specific store personnel the duty of periodic inspection of the aisles for debris, breakage, and improperly arranged displays of goods. Employees should be trained to recognize and eliminate dangerous in-store situations. They also suggest that time intervals between inspections need to be established and followed. Depending on the situation, the established interval may need to be shortened. So, for instance, a store may find that an interval of 30 minutes might be appropriate for monitoring its entrances and exits. However, on rainy days, a cleanup person with a mop and bucket may need to be constantly monitoring and working to eliminate water accumulation hazards. And then finally, they suggest that you enlist the aid of your liability insurance carrier in your efforts to control costs. Most insurance carriers can and regularly do provide risk management assistance to clients. Now we're moving on to the tort of nuisance. The tort of nuisance attempts to address conflicts between neighbors stemming from how they use their land. The tort of nuisance comes into play when one neighbor interferes with the land use of another, because the law says that individuals have a right to enjoy their land or their property uninterrupted. So some of the actions that could cause these interruptions can be intentional or even unintentional, such as machinery noise or unpleasant odors emanating from some process on the neighbor's property. In order to prove nuisance, the action has to pass a 2-step test. So, the test is this: does an activity of an occupier's property A, unreasonably, and B, substantially interfere with the neighbor's rights to use and enjoy their land? And so the first part of the test is you've got to prove it's unreasonable, and the second part of the test is you have to prove that it is substantial. Typically, nuisance doesn't arise where the intrusion is only temporary or in cases where the activity is for the public good. So temporary, if you are having a garage constructed on your property and the construction is going to be noisy, but it's only going to last about 3 days, the court wouldn't consider that to be nuisance. Public good is perhaps there's a large farm in the neighborhood, it's been there for decades, and when they fertilize their fields, there might be a smell that emanates from the fields. If the courts tried to address smells emanating from farming operations, this would be contrary to the public good. There's actually special laws around smells and sounds that come from farm properties. So now we're going to look at the case of TMS Lighting versus KJS Transport. TMS Lighting manufactured high-end lighting in a prestigious industrial area in Ontario. It had purchased that specific location because it required clean and dust-free premises for its facility. KJS Transport, a long-haul trucking service, moved in next door and did not pave their parking lot. As a result, dust blew in and damaged the lighting being manufactured next door for 4 years. TMS tried different things to fix the problem, but even when the windows and doors were closed, the factory fans would still draw in dust and the heat became intolerable. When it became too hot, production had to slow down or halt altogether. So, TMS's manufacturing process was adversely affected by dust emanating from the KJS parking lot. KJS tried the remedial option of putting down gravel and erecting a tall fence. However, paving, a relatively costlier option, appeared to be the only effective solution to the dust problem. So the legal question here was, has KJS committed the tort of nuisance? And the resolution was yes. The frequency, duration, degree, and impact of the dust generated by KJS trucks caused a continuing and substantial interference with TMS's manufacturing operations. The court held that the interference was unreasonable given that the dust problems began in 2007 and were not resolved until 2011. So the legal rules resulting from this case would be that nuisance involves an interference with the plaintiff's use or enjoyment of the land which is both 1, substantial, and 2, unreasonable. The court defined both of these, and you can get a little more detail on how they were defined on page 289. Just for interest's sakes, I'm going to fill in a few more details. There was some evidence on the cost of paving at trial, including as follows. I'm going to read directly from the case. So Mr. Singh, who was KJS's representative, produced an invoice dated June 7, 2011 for $70,000 from Triple Star Paving for asphalt paving. Mr. Singh explained that the paving was to eliminate the dust. He acknowledged, however, that the second page of the invoice shows that the charge for asphalt was for the rear parking lot was only $10,000 and that the balance of the invoice was for a 4-foot wide, 4-inch thick L-shaped concrete path. So basically, he produced an invoice that said, it would cost $70,000 to do the paving. Upon closer examination, it was only going to cost $10,000 for the paving that would solve the dust problem at TMS Lighting. Regardless of the exact cost of paving, it is possible that TMS could have offered to share in the expense, given the defendant's reluctance to get the work done promptly. This could have produced a solution that would have been less costly than taking the matter to trial. It's unknown, though, whether the defendant would have agreed to such a proposal, of course. So the defendant pled poverty in court, saying it could not afford the cost of repaving at the time the problem of dust arose. This excuse did not appear to have been accepted by the court. According to the trial judge's decision in TMS Lighting versus KJS Transport, the court said as follows. While Mr. Singh sought to explain KJS's delay in paving its parking lot by suggesting that it could not afford to undertake the paving at an earlier time, he admitted that Pardeep Singh paid KJS $7,000 per month for rent and a further $5,000 to $6,000 per month for transportation services, for a total of $10,000 to $12,000 per month. He agreed that this amounted to $120,000 to $140,000 per year from Mr. Singh alone. So they were not successful in convincing the courts that they could not afford the $10,000 for paving. Given the circumstances, TMS might have tried mediation and arbitration, but this is not always a viable option. It seems in this case that the proper fix was known, paving, but the defendant simply would not agree to take that step. In the circumstances at bar, perhaps nothing short of litigation likely would force the defendant's hand. Now we move to the tort of trespass. Trespass can occur when a person comes onto the property against the occupier's express or implied wishes, or comes onto the property with the occupier's express or implied consent, but then is subsequently asked to leave. Any person who refuses to leave becomes a trespasser. Additionally, it is trespass to leave an object on the property without the occupier's express or implied permission. Interestingly, trespass is actionable without proof of harm or damage, so there doesn't need to be any harm or damage to the land. If there are damages, they are also recoverable. The most common remedy when we talk about trespass is an injunction. Think back for a minute about how we defined what an injunction is. Remember, an injunction is an order to stop doing something. So in the case of trespass, it would be to stop trespassing. So we're going to look at trespass now, and we're going to use the same case as we did when we talked about nuisance. So we're back to TMS Lighting versus KJS Transport. There's all kinds of trouble going on here. KJS, the trucking company, owns some very large trucks. These 18-wheelers would often pull into TMS Lighting's driveway because they didn't have enough turning radius on KJS's premises. The lighting company was not happy with this, and to prevent it from happening, they installed a 6-inch high concrete curb along the edge of the factory driveway. The trucks, however, simply drove over them and ultimately destroyed them. So the lighting company tried again. They installed 3-foot high concrete blocks, which the big trucks continued to strike and ended up pushing them right into the lighting company's driveway. This blocked the driveway, requiring them to send employees out with forklifts to move them back into position. Clearly, there was some animosity between the two businesses, as this is not typical behavior that one would expect from companies of this sort. So the legal question in this case was, has KJS committed the tort of trespass? And the court found yes, they did. The court ordered an injunction to prohibit future trespass and compensation for the destroyed barriers. So TMS got paid for the barriers that the trucks destroyed, and KJS was prohibited from trespassing in the future. However, TMS was also claiming lost productivity damages for having to constantly reposition the concrete barriers. A new trial was ordered to address the issue of losses or damages for lost productivity for procedural reasons, so we don't have the solution to that part of the case. Legal rules that we do have from the case is that trespass occurs when it causes a substantial interference with the plaintiff's rights, and we call this wrongful interference. So the last thing we're going to take a peek at in this lesson is tort actions relating to the environment. So at common law, there are 4 main torts for environmental damage. The first is the tort of negligence. Just as the other cases of negligence we talked about, when we're looking at negligence from an environmental perspective, all elements of a tort action have to be proven. Another tort action relating to the environment could be the tort of trespass. So in this case, they must show direct intrusion into the plaintiff's land, as we just discussed. We also can look at the tort of nuisance when it comes to the environment. And again, when we're looking at the tort of nuisance, they must show reasonable and substantial interference with the plaintiff's rights to the enjoyment of their own property. And then the last one, in terms of the environment and tort law, are actions based on a case called Rylands versus Fletcher. And I'm going to explain that case to you. So in Rylands versus Fletcher, which is a case from 1868, but is still good law, the defendants employed independent contractors to construct a reservoir on their land. The contractors found disused mines when digging, but failed to seal them properly. They filled the reservoir with water. As a result, the water flooded through the mine shafts into the plaintiff's mines on the adjoining property. The plaintiff secured a verdict, and the court held the defendant liable. And this was later then, it went to the House of Lords where it was affirmed. In a case like this, where water is put in a reservoir and then it floods a mine, the tort of trespass is inapplicable because the flooding was deemed not to be direct immediate. As well, the tort of nuisance was rejected because it was a one-off event. It only happened once. Thus, in Rylands and Fletcher, a rule was established that said this: the person who for his own purposes brings on his lands and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damages which is the natural consequence of its escape. So in this case, we're talking about water in the reservoir. But it could also be fumes, it could be chemicals. And so if we bring this onto our land and we keep it there, and it somehow escapes, then under Rylance and Fletcher, a tort action could be successful. As you may recall from the beginning of this course, there are pieces of legislation at all three levels of government that relate to the environment. And the main advantage of environmental regulations via environmental protection legislation is that it's more flexible than private action. It resolves the problem at the legislative level and avoids the often unsatisfactory road of litigation, which can be costly and slow. In addition, the common law is often harsh and inflexible. Municipal zoning and land use planning laws make it clear what type of development and activities can take place in certain areas. Legislation removes the uncertainty of what can be done where, how, and when. So as we've just learned, there are tort actions relating to the environment. However, the law has attempted to simplify environmental protection through legislation. So that's it for the Module 3, Lesson 3A. We have 2 more lessons to go. As always, if you have questions or concerns, send me an email and we'll get in touch. Bye for now.